Friday, I said I would make a ruling today. And I want to emphasize, it is a ruling, it is not a judgment. It is a ruling on a point of law. But it also happens to be a constitutional point. When Mr. Baloyi intended to cross-examine Mr. Sibisi using the statement or the confession of Mr. what's his name, accused number 2? Mzansi. I said to him, is that the correct procedure? Is it admissible, the evidence you're going to adduce? Then Mr. Baloyi addressed me, and thereafter the whole defense team addressed me. Right, so that is the reason this court said maybe it would be infringing on the rights of accused number 2 to use number 2's statement or confession to cross-examine Mr. Sibia.
When my lord started off with, it's a ruling. Okay, it's a ruling and not a judgment on a point of law, which also happens to be a constitutional point. I said, there we go. There we go. Got him. They got him, and they got him really good. Well done to the defense team for the heads of arguments and the strategy they played, which was give him the law. He always wants the law. Give him the law as it is. But in this case, ladies and gentlemen, his own law came to bite him in the behind. Hello, everybody. Welcome back to another Mzansi Unfiltered edition, special edition in this case, where we talk about the just delivered judgment. No. He did say we must call it a ruling. The just delivered ruling where Advocate George Baloyi was left stunned. He was so stunned he didn't know, are we supposed to take the short adjournment or not? Sir, when did you not take the short adjournment? My lord, yes, as the court pleases, has ruled in favor of the defense, a sentence I barely say, I want to say I've never said, but my lord, Judge Rata, has literally gone ahead and ruled in favor of the defense because the defense put it on record that, hey, excuse me, you, Judge Rata, the court, the honorable court, ruled in a trial within a trial that the confessions are admissible. Confessions, not executive statements as Baloyi is trying to pass them right now. Confessions. And guess what, everybody? It's on the record. You see, you gotta fight fire with fire. And as they say, only tough times don't last. No. Only tough people do. Let's go ahead and listen to this moment because, in my opinion, it is epic. But we hear the judge struggle. For example, you hear him say, maybe. So we're not looking for maybes here. We need you to sound assertive and firm in your ruling. But here goes.
All right. The common law exception. At common law, there is an exception to the exclusion of extracurrial statements of co-accused if the statement constitutes an executive statement by an accused. This court has not made a finding that the statements of any of the accused, 1 or 2, are executive statements. Persons or people must remember that this case is still continuing. That election will be done by this court at the end of the case after all the parties have addressed the law, the facts. But at this moment, this court is still continuing. Only one accused person has given evidence, although he has not yet completed his evidence. So that's the reason I say I'm not interpreting the law. I'm just saying this court has not as yet said any of the statements here of either 1 or 2 constitute an executive statement that is by an accused. It may be admissible against a co-accused if it was made in furtherance of a common purpose or conspiracy. This court has also not made a finding as to whether all these accused before court acted in pursuance of a conspiracy or a common purpose.
I've never seen my Lord spend so much time in clarifying and make sure that we, Vondava, understand clearly what he is doing. First of all, he tells us it is a ruling, not a judgment. We are familiar with that. You told us within a trial. So we know exactly where you're going with this. Don't worry. We are clear on that it's a ruling. Next thing he says, he also hasn't made a finding about was it a conspiracy or common purpose. He is simply addressing the scam. Yeah, let's call it that. The scam that Baloyi was trying to insert inside Pagati within the SENZO MEYIWA trial and have almost a severe accused number 1 go ahead and be cross-examined using the statement of Bongani Ntanzi. The audacity, the nerve. And then Baloyi changed it from a confession and pointing out to a executive statement. Baloyi must have thought the defense team went to law school at night, because what is this? Him and Brigadier Bongani Nicholas Gininda definitely did not see this coming. But am I enjoying it? Yes or yes? Yes. Let's continue listening on.
Right. There must be other evidence aliunde to establish the existence of a common purpose before the statement can be taken into account. This court has not pronounced on the evidence aliunde. This court may have pronounced on the application lodged by by accused number 4's counsel when he was bringing an application, that is Mr. Mapisa, when he was bringing an application on behalf of Mr. Mapisa. All the court pronounced upon was that the evidence of Zungu was not so hopeless that it can be thrown away. And that is the only attack Mr. Ngumalo made in that application for 170. And I opined that there's other derivative and constructive evidence which was led in this court. For instance, I said there was evidence pertaining to cell phones, etc. So this court never pronounced itself on the other evidence which Mr. Ngumalo ignored. And I said the case against the accused is not only predicated only and solely on the evidence of Zungu. Consequently, that's why I say there's merit by the defense to say that at this juncture, there is constitutional invalidity regarding Mr. Baloyi's attempt to take the statement of accused number 2, who has not yet cross-examined Mr. Baloyi, Mr. Sibiya. And that is frowned upon by section 9.1. And consequently also it infringes section 35 of the Constitution regarding the freedom of a litigant or an accused person to give evidence and attack the evidence of a co-accused if he so desires. Consequently then, the ruling I made against Mr. Baloyi stands that he cannot use the statement of accused number 2 to cross-examine accused number 1, because of the experiences which I have mentioned, that no pronouncements have been made regarding the status of the statements or confessions or pointing outs. The case is still ongoing.
My lord, you absolutely had no choice, but as they say, as the court pleases. This was so satisfying to listen to. Absolutely satisfying, because he's taking pieces of what was in the heads of arguments, which is just a testament. It's Monday, okay? English bundles are not yet charged. Which is a testament to the brilliance of the heads of arguments that the defense put to my lord, which I did a review. If you didn't catch those, make sure you do, because those were quite interesting for me. And of course, members of the public jury, I saw all your comments. So he mentions, he quotes that there is merit. Ooh. How does my lord use the word merit and defense in the same sentence? Yet only last week he said you are supposed to be intelligent as lawyers. So he says there is merit by the defense to say that at this juncture, there is constitutional invalidity regarding Baloyi's attempt to take the statements of accused number 1 and use it, of accused number 2 and use it to cross-examine accused number 1, and is frowned upon. I couldn't believe he used merit and frowned. Wow. And is frowned upon by section 91. He continues to say, Baloyi, pay close attention, and Geninda, come to the front of the class. It infringes section 35 of the freedom of an accused person to attack evidence of a co-accused. The ruling I made against Mr. Baloyi stands. He cannot use the statement of accused number 1. However, let it be clear to Abondaba, no pronouncements have been made in this case because it is still ongoing. Do not be deceived by this moment of weakness where Baloyi has exposed me as the judge and I must rule against him. Do not be deceived, because this is not a pronouncement. This is not a judgment. It is a ruling. And by ruling, he means he can change his mind at any given moment throughout the trial as more and more evidence is adduced to my lord. With that, I'm going to end this video right here. Let me know your thoughts in the comment section down below. Did you predict my lord was going to do the honorable thing? As the court pleases, we, as members of the public jury, are indebted to the court. And I'm going to end this video right here. If you've made it this far in the video, thank you so much for watching. Remember to like, to comment, to subscribe. I'll catch you on the next one. Bye.